the collective bargaining agreement, right? So we know that if what happens if you want to organize a union, what must you do? What's your first step?
Get an authorization card.
Authorization card campaign, right?
Yeah.
And if you get, what's the percentage of cards you need to get signed, the minimum?
30.
But what is the optimal percentage?
100.
100%, right? If you get that, then what do you do next? What do you do next after you get the cards?
Take it to
What do you do? You take it to management, and what do you do? You what?
You let them know you want to be represented.
You say you what? You request what?
Representation.
Request recognition, right?
My bad, I'm sure.
Of the union that has been designated as your sole representative, right? For collective bargaining purposes, right? And what happens if they say no, Mr. John Pong? Mr. John Pong, what happens if they say no?
You have to go by collective bargaining.
If they say no,
They have to redo the process again.
Mr. Fitzgerald, I'm sorry, Mr. Jackson. They say no. What happened?
They got to do it again. Go through the whole process.
If they say if you've gotten 100% of the cards, you request recognition, Ms. Latney. If the management says no, what happens then?
Can I get my point real quick?
Hold on, bud.
I'm trying to knock this out.
Latney. Latney. Talking to you.
Oh, then it goes to that.
I know, we talking to you though. I know, but we're still talking to you.
Yeah, she hasn't exact, you know.
She a little busy.
Do you know the answer?
Then you have to go to the NLRB.
If they say no, then you do what?
You heard?
You
Take it to the NLRB.
and you say and what happens?
When you sign a petition, well, do a petition
For what?
saying that you. Election. I'm sorry.
You petition the NLRB for a NLRB, right, supervised election. And then going back to you, Mr. Chompong. So what if how much do you need? How many votes do you need in order to have a union created? What's that? Miss Latney? How many votes do you need in order for you to actually get your union established? What's that? 50 plus 1, right? 50% plus 1. And again, if you get that number of votes, then what happens, Mr. Jackson?
Then you do the. Election.
No.
Negotiation. Collective bargaining. Negotiation for collective bargaining.
Bargaining what?
Agreement.
That's the chapter that we're in right now. So again, everything that we have done up to this point has been to get us to this chapter.
525.
Thank you. But if you all don't remember what it is that we have done, then you're going to be lost. So you can't just learn the information, Ms. Lattin. You can't learn this information and just forget it. You got to continue it in order for you to be able to kind of maintain your ability to converse in this class. Does that make sense?
Yeah.
All right. Let's see.
Can't sit down so I
He said have a seat.
MVP. Huh?
So, we'll come back to you, though, Ms. Lattin. Come back to you, Ms. Lattin. So again, the conversation that we're going to be focusing on again, as I said today, is what is involved in a collective bargaining agreement and what is what are some of the tools that may be used, right? You know, what does competition within the product marketplace, what factor does that have on the collective bargaining agreement? What effect does unionization have on the wage and employment decisions of employers? What influences do laws and regulations have on the issue of collective bargaining? How does globalization impact issues that might come up in a collective bargaining agreement? What do joint decisions between employers and unions have? What impact do they have on collective bargaining agreements? And how do economic conditions impact collective bargaining agreements? So those are the things that we're going to be talking about. But before we move on, I want to ask, come back to you, Ms. Latney. What is the law? What is the law that provided the basis for collective bargaining agreements? What is the law? And when was it passed? What was the law?
Was it the Wagner?
What was the first? There was two laws. Two laws. Let me ask Mr. Mason. I'm sorry. What was that? The Wagner Act is one. And what is it? What was the first one though? What was that?
The railway.
Look in the look on page 221. The Railroad Labor Act. And what is it? And what does it provide?
The exception of emergency periods such as World War I and severe labor unrest. Issue bargaining power to deal with each other without government involvement or intervention.
Well, okay, but I mean, you read the information there, but you didn't answer my question. And that goes back to my other point that I've raised several times in class. And that is, you have to review your PowerPoint presentation at minimum. And I'm going to say this only one more time. This is the last time I say this. If I get 3 students, if I ask a question, and you can't get those three students, and I'm going to ask a question. If I get to a point where I notice that 3 students in a row can't answer questions that are in the PowerPoint presentation, I'm going to call a snap quiz. All right? Now, again, I'm only saying that to you because you know that, you know, the reading is a must, right? And that's just at a minimum, review the PowerPoint presentation. Have it up. You know what I mean? So I'm going over the questions that come directly from that. So the 19th, now when does it get passed, Miss Laddie? The Railroad Labor Act?
19.
And what is it? And what does it provide? What does it do? What did the 1926 Railway Labor Act do? Tongue twister. Exactly. The National Mediation Board was created, again, perhaps to particularly resolve disputes between transportation workers when they were negotiating with their owners. All right? So then, what happened after that? tell me what happened after that.
Employers and unions could not agree on how an industrial conflict was to be resolved.
And then again, the National Mediation Board was created just to bring about that resolution, right? But then what happened?
The National Mediation.
And what did the National Mediation Board do? What is it?
Assist emergencies. Boards could not be convened and ultimately Congress.
Could be convened, right?
Could be, yeah, convened. And ultimately Congress was empowered to impose solutions when the parties were unable to do so.
All right. And then what happened in 1936?
The Wagner Act was established.
And what vehicle did the Wagner Act create?
Is that a vehicle?
Right. What mechanism for resolving conflicts were created by the
Methods for resolving the labor disputes and situations.
what method? What method? What did it establish? It established what?
Collective bargaining as the preferred method.
Exactly. Collective bargaining was the method that was created as a result of the Wagner Act. And what's the difference between the, you can have a seat, Mr. Mason. What was the difference between the Wagner Act and the Railway Labor Act? Mr. Mason?
The Wagner Act did not create laws and regulations for dealing with impasses, but rather listed a set of prohibited practices for employers and left it up to the parties to negotiate a solution, taking into account their relative bargaining power. So the Wagner Act didn't create laws. The RLA did.
Okay. And so then what did the Taft-Hartley Act do on top of the Wagner Act?
The Taft-Hartley Act shifted the negotiating environment toward a more corporatist perspective by establishing the Federal Mediation and Conciliation Services, the FMCS, to help parties reach agreement in difficult situations, legislating rules for so-called national emergency disputes that would temporarily enjoin strikes and require fact-finding and defining a set of union unfair labor practices to balance those that the employer was forbidden to use.
All right. And so again, these laws, these series of laws, first of all, the 1926 National Railway Act, then the 1936 Wagner Act, and then finally the Taft-Hartley Act. These are three pieces of legal authority that you all will need to understand. All right. So, thank you. One other question. Thank you. One other question before you sit down.
What's going on?
Let me ask you this. What, in the context of the Taft-Hartley Act, how did it establish a more corporatist perspective? What is one of the things that it created? We talked about the National Mediation Board, right?
Yeah, you talking about the FMCS?
What is the FMCS?
The Federal Mediation and Conciliation Service.
And what did it do?
It helps parties dispute their arguments.
And helps them to reach settlement, right?
Yeah.
And also, let me ask you the question of this. How would you define bargaining issues in terms of the legal category? how can bargaining issues be defined by in terms of legal consequences? If you were going to group them into 3 areas, what would one area be?
Mandatory bargaining issues.
Mandatory bargaining issues is one, right? And they deal with what? What are the mandatory things that you need at minimum?
They deal with wages, hours, and other terms and conditions of employment.
Exactly, right?
Yeah.
The second one being what?
Permissive bargaining issues.
And what do those deal with?
They do not require a response because they have no direct impact on management or labor costs. A demand by a union to have a say in the establishment of company product prices would be permissive.
Exactly. And then the last legal issue would be
prohibited bargaining issues.
And what are those?
They are statutorily outlawed, such as.
What does that mean?
Statutorily outlawed?
Yes, what does that
mean? I know what the statute is.
What is a statute?
The statute, it's like a legal, yeah, something like that. It's kind of like it's prohibited to be done. You can't.
A statute is what?
No.
Law.
There you go.
That's what it is. A written law.
Yeah.
Today, for example, I was with a client before the Prince George's County government, and they had a zoning law that they said required that if you wanted to operate a Airbnb in your house, you would have to obtain a occupancy permit that allowed you to have either a bed and breakfast or a rooming house. That was, again, in the statute, right? So, again, that is a written embodiment of the law. That's what it is, right? So, again, tell me, what is a prohibited bargaining issue? You said there, again, what? Statutorily outlawed.
Yeah.
And so what is an example of a statutorily outlawed bargaining issue?
Says such as demands that employers use only union-produced goods.
So again, these are prohibited by what? Which law prohibits that?
Statute. You're talking about
which statute?
Which statute?
Mm-hmm.
540.
Thank you.
I can't even think of it right now.
So
I heard this before though.
this is something that we probably will either get to or will assign as a homework assignment in terms of understanding what statutes prohibit a contract that would require only union-produced goods. All right. So what happens if you have an impasse when you have a mandatory bargaining issue, Mr. Mason?
Let's see. I'm sorry. Can you repeat the question?
If you have a mandatory bargaining issue,
Right.
and you have an impasse, what happens? What is an impasse?
Go to impasse.
What is an impasse?
The refusal to agree
Exactly.
to a contract.
You got a conflict,
Yeah.
right? So if you have a mandatory bargaining issue
Oh, do you have a lockout?
and you have an impasse, then what has to happen?
Is that when you have like a lockout, like an NBA and stuff?
If you have a mandatory issue, then again, those are
The wages.
when, again, wages, right?
Yeah.
And so when you have a impasse over a mandatory thing that absolutely has to be agreed upon, what has to happen?
You have to come to an agreement.
Like, do you have to meet again and then tell them that
You have to find an agreement, right? Look at the chart on page on 8.1, right?
Yeah, that's it. On 223.
Pull up this, right?
I don't see chapter 8 on the platform.
It's not on there.
Pardon me?
She was looking for the slides.
It's on there.
Blackboard.
It's on there.
Is it under course materials?
Yep.
I'm about to say it only goes up to 4 for us. It may not be visible for us.
I know.
My leg's about to be swollen.
Tell me, boy, he giving you the whole
Gotta
shot.
hit these toe raises.
Yeah, he giving you the whole shot. Knock that out, baby.
I just got this on? Holding Air Force Base? This sweet money.
Oh, man.
Jump some rounds. Boy, you could go jump around in cycles.
I came in smelling like that.
All right.
Nothing
That's
93.
Hey, how you do that? Yes, man.
So you,
So what's it mean?
it's in your pores.
Pardon. Why I gotta be me, fool?
Know about you.
But y'all know what he know, man. Just look. Just let that, hey, go ahead.
All right. All right. So again, you can take a look at it, but again, let's take a look at right now this chart here, right? So in this chart, again, it talks about how issues that are mandatory are dealt with versus when they are permissive. So again, when you have an internal union affair, right, which are matters relating to relations between the relationship between unions and employees, that's put on the upper end of the spectrum, right? Another one is that when they're totally in the management domain, also matters dealing with the actual business function itself, right? Then the other issue is if there's an employment issue, which are dealing with the relationship between employees and employers. Now, they can be divided, that latter one, into whether or not they have a significant impact upon employees versus an insignificant impact. If it has a significant impact on the relationship, then that is considered a what? Mandatory or permissive? If it is a significant impact, what is it considered?
Mandatory.
Mandatory. Right. If it has an insignificant impact upon employees, it's considered what?
Permissive.
Permissive. Similarly, in things that deal with the management's control, if it has, again, an indirect or uncertain impact upon employees, then it is what?
Permissive.
Permissive. However, if it has a significant impact on employees, then it is what?
It can be mandatory or permissive.
It all depends upon what?
The
It
decision.
determines
The decisions.
and cost. Exactly. So if something that actually has a lot of cost, then that is going to be, again, a mandatory issue, something that they absolutely have to negotiate. All right. This is the whole issue here. And the union bargaining power increases the likelihood of dealing with permissive issues in the contract. All right. Permissive issues are not included as frequently whether in issues where these distinctions are made. Right. So the whole idea of having a union allows you to get more of those things that are not mandatory in your contract, all right? So again, the idea of, again, like was stated earlier, the ability to say what type of thing you actually produce. That right now is something that, again, an employer doesn't have to reach an agreement on. He has to reach an agreement about how much money he's going to pay you. He can't basically pay you nothing, for example, right? So again, these are the key issues to understand. All right, you can have a seat. So tell me about the historical context. Miss Mathis, walk me through, if you will, like a history of when the spectrums were shifting one side to the other, shifting towards the workers versus towards the business. In the beginning, what was the scale? Was it in favor of the workers, or was it in favor of the owners? So, you're right. And in the context of, generally speaking, courts favor which right? Property rights versus labor rights. Which rights do courts generally favor?
Was it labor?
No, ma'am.
Property?
Exactly. What does the book say about that? During all periods, right? Courts have generally held that what? Help her out. So you had again, we talked about the scales, right? The scales is that in that the scales shifted. On the one hand, generally the laws, particularly court decisions, favored the owner's property rights above the labor rights. However, when Congress stepped in to pass laws to protect the workers, the courts have generally upheld the legitimacy of those laws, right? And let me ask you this, thank you. What kind of, in terms of periods of years, when was the scale tipped generally between what years and what years could you say the scales were tipped in favor of the corporatists or the employers?
Was it between the World War II and the middle of the 1970s?
Which period was that? Was that the corporatist period or the labor period, if you will? Was it favoring the workers or was it favoring the owners?
Labor.
It's favoring labor, right? Again, so you want to understand that most of the laws that began to protect the laborers came out of the beginning of World War II until the middle of the 1970s. That's when you had the peak. After that period, you had a waning of laws, right? Particularly in the time of President Reagan. President Reagan came in as a Republican to try to dismantle a lot of the progress that the labor unions had made. And over the 30 years since, union membership and union rights have increased or declined? Decline. All right. That's the strong. That's a strong understanding of history, and it's going to come back in the context of understanding what negotiations have taken place in terms of collective bargaining agreements during that time period. All right. So tell me about. You can have a seat. Now, again, in addition to laws and regulations, as has been stated before, to support collective bargaining agreement, other laws have been created, and we discussed these earlier, to regulate wage and hour rules, to prohibit child labor, to provide employment-based social welfare programs, including Social Security benefits, prohibit discrimination in employment, such as Title VII of 1968 Civil Rights Act, to promote health and safety in the workplace, and to regulate private pension and benefit programs. Right? Those are some of the things that in addition to the labor laws that we have that protect collective bargaining rights, we can rely upon. But let me ask you next, Miss. That was Miss Mathis, right? Let me ask you now, Miss Olatunji. Tell me about the impact of competition in concentration or consolidation. What impact did that have on collective bargaining agreements? So Olatunji.
Public policy has been limited.
Olatunji.
Public policy has been limited by the industrial concentration and collusive activities between producers in a single industry.
So you're saying to me that, again, in the context of collective bargaining, has competition enhanced the ability for the unions to negotiate, or have they decreased the abilities for unions to negotiate strong collective bargaining agreements?
Increased it.
Increased it? So let me ask you this. So when you have a competitive market, what are some of the characteristics of a competitive market? What are some of the characteristics? What happens when you have a competitive market? In terms of pricing, you mentioned pricing. What happens to pricing? Are prices high or are they low?
They're higher
They're higher?
or lower. Sometimes higher, sometimes lower. It can go either way.
Well, producers that sell at prices above the market in a competitive environment, can they survive?
No.
No, they can't, right? So tell me about, again, what happens on the opposite end. So on the one hand, you have a competitive environment. And a competitive environment are the labor, so in that context, are labor rights, the ability for labor unions to negotiate, are they higher when you have a competitive environment? Yes, right? Because when you have, again, a competitive environment, that means that essentially every owner is basically jockeying for the best product, right? And if you want the best products, you want to actually also have the best what? Workers, right? Think about it. Think about the negotiation between football and basketball players, right? So you had a situation, right, with the trading cap, the deadline for trading people in the NFL, right? That was this past weekend, right? So you had owners jockeying for who? The best players to pick up to add to their team, right? So when you have a competitive environment, so when again the league is at its peak, when there are a lot at stake, a lot of viewers are watching these games, the people are going to pay. Are they going to pay top price for the players or basement bargain price for the players? Again, when lots are at stake, and the viewers basically and the owners are vying for viewers to watch their game, do you think they're going to pay more for players or less for players? More for players, right? So that's the concept that we're trying to talk about. When you have a competitive environment, then workers can actually get more in that type of environment. But tell me what happens when you have, a monopoly. What happens then?
The demand for goods and services are highly elastic, meaning that producer increases prices, buyers will quickly set toward purchases from this low-price firm. The reverse would happen to producers that do not respond to the decrease. In a competitive market, if a producer does not...
So let's just stay on the concentrated market, because I think our analysis may be reversed. In a concentrated market, we have, again, relatively few producers. Let's say, for example, in the context of intercontinental airlines is discussed, we have, let's say, Airbus and Boeing. The investment necessary to enter the industry in both financial and production prevents other players from getting into this, right? This market. So because of that, you don't have, again, you don't have a race to the bottom in terms of price, right? So you're able to actually get more money for your goods. However, because you're able to get more money for your goods, is that good for labor or is that not good for labor? When you have more money for the price of your goods. It's good for labor. When you get more money for the price of your goods, then the employer should have more incentive to pay you more, right? And this is what turns on. It says that organizing one company gives the union virtually no bargaining power on wages when there's a competitive environment, because there are a number of different sources for that particular market or that particular product. However, that if you have a concentrated industry, then it's important for unions to organize most or all employers to bargain with them on the same time schedule. That way, all employers will encounter the same demands and will have less and will be less resistant, because at least part of the negotiated wage increase can be passed on to consumers through simultaneous price increases. So again, with high-priced goods, and if there's only a certain number of places that you can get those goods, then unions generally tend to fare better. That if you have a competitive environment, then unions tend to fare worse, according to the book. And again, that makes some sense, which is the reason why for example, in the technology space, there's more competition, and those are environments in which labor unions have not fared as well, as opposed to, for example, in the context of manufacturing airplanes, for example, where a number of those workers are actually